Assalamualaikum and good evening. My name is Wan Nur Ilmi Hasanah Binti Wan Noor Ikram and my metric number is 077549. This presentation reviews the case of Public Prosecutor against Syahrir Muhammad Sarif 2025 decided by the High Court of Malaya, Kuala Lumpur, focusing on the facts, legal issues, judgment and critical commentary. In this case, the accused was charged under Section 233, Subsection 1, Subsection A of the Communication and Multimedia Act 1998 for publishing an abusive Twitter post that allegedly caused annoyance and insult. At the Sessions Court, the accused, who was unrepresented, pleaded guilty but claimed that he was mentally unstable at the time of posting. The court then ordered psychiatric observation. A forensic psychiatric report P4B prepared by a specialist psychiatrist confirmed that the accused was suffering from schizophrenia at the material time, affecting his awareness and judgment. But despite this, the prosecution proceeded with the case. The Sessions Court eventually acquitted and discharged the accused at the close of the prosecution case. The public prosecutor appealed against this decision. So, there are a few legal issues arise in this case. Firstly, whether Section 233, Subsection 1, Subsection A of the CMA requires proof of mens rea or is it a strict liability offence? Secondly, whether mens rea can exist where the accused was mentally ill and unaware of the nature or illegality of his act. Thirdly, whether actus reus alone is sufficient to establish criminal liability for a cyber offence. So in this case, the High Court dismissed the prosecution's appeal and upheld the acquittal. The court held that Section 233, Subsection 1, Subsection A is not a strict liability offence. The prosecution must prove both actus reus and mens rea beyond reasonable doubt. Although the offensive communication was published and capable of causing annoyance, the court emphasized that mere effect is insufficient. What must be proven is the intention to cause such harm and annoy. Crucially, the psychiatric report showed that the accused was suffering from schizophrenia at the time of the offence and was unable to understand the nature or illegality of his action. So this negated the element of mens rea. The court further found that the accused fell within Section 84 of the Penal Code relating to the defence of legal insanity. Since mens rea was absent, proof of actus reus alone could not sustain a conviction. Accordingly, the Sessions Court was correct to acquit the accused under Section 173, Subsection H, Subsection 3 of the Criminal Procedure Code, and no appellate interference was justified. So, critical commentary in this case, we could see, firstly, while the decision is legally sound, it raises concerns regarding justice for the victims. Section 233 aims to protect individuals from online harassment and reputational harm. But yet, the strict requirement of proving intent places a heavy burden on the prosecution. Where mens rea is excluded due to the mental illness, victims may be left without any criminal remedy despite suffering real and lasting harm in the digital space. This exposes a tension between moral culpability of the accused and also victim-centered justice. Not just that, this case also highlights the absence of accountability for platform harm and the wider digital ecosystem. The accused was fully acquitted with no treatment order, monitoring mechanism, or even restorative measure imposed. While doctrinally correct, this creates the perception that harmful online conduct linked to mental illness goes unaddressed. This exposes a legal gap and suggests the need for intermediate responses such as supervised treatment orders or restorative approaches to balance public protection, mental health consideration, and non-punitive accountability. So, in conclusion, the case of Public Prosecutor against Syarif Muhammad Sarif affirms that mens rea remains essential under Section 233 of the CMA and reinforces the role of psychiatric evidence in determining criminal liability. But however, it also exposes structural weaknesses in addressing victim harm and digital accountability in cases involving mental illness. That's all from me. Thank you.